crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Hello and welcome into the attorneys. Thank you so much for joining us tonight. Real estate is hot. It's a hot topic, and it is our topic tonight. We've got a panel of experts all ready to talk about everything you need to know of what to watch out for and just kind of all helping us understand what's going on in the market. We'll get to that in just a moment. First, though, before we introduce tonight's guest, I want to remind you of how you can be a part of the conversation. All throughout the show tonight, at the bottom of your screen are ways you can call, text, email, and get in touch with us. We would love to hear from you. Also, Hollis Wright makes available attorneys who are standing by live for a free off-air and confidential conversation. So an opportunity to get some free legal advice tonight during the show. All you have to do is get in touch with them. So take advantage of that over the next half hour. Leading our conversation is Michael Eldridge from Hollis Wright. Good to see you, sir.
Good to see you tonight, David. How are you?
Doing very well. How about you?
I'm doing pretty good, all things considered, staying busy.
There is a lot going on at the firm for sure.
Absolutely.
And especially with tonight's topic of conversation, man.
It's busier than we are, for
It
sure.
is, yeah.
At least from what I've heard. And it's one of those topics that I think I'm more interested in the answers to questions than our viewers are, because it is a nuanced area, certainly of law, but it's a totally different industry from law. And as you said, that's real estate. And so we brought in Damon Ryals, who is an expert in this, to answer some questions for our viewers. He's with the Ryals Law Firm. Damon, tell us tell us about your practice and what you do day to day.
Yeah, so we represent clients ranging from large multinational banks, government entities and government-sponsored entities, all the way down to small investors and small businesses right here in the Birmingham, Jefferson County area, with primarily real estate-related matters and transactional work and business-related and business entity-related matters, which include foreclosure, ejectment, a great deal of title clearance to get properties in shape to be bought and sold, and also assist clients with entity formation and a great deal of transactional matters related to investing in real estate.
Awesome. So we get calls all the time, and we have clients that talk to us all the time, and they say, I want to deed this property to my son, or I want to do this with this piece of land. And I know it's going to be a very elementary question, but obviously, real estate as property is different than our other property, like our cars. Mm-hmm. Explain that. What is the difference between real estate and other property? So,
real property is unique in that it's in a specific place, it's fixed, it's immovable. Real estate is not just land, though. It's the buildings and roads, mines, things that are permanently attached to land. Okay. And so there are ways in which other types of property, and the other types of property are particularly personal property, can become part of the real estate. So for example, when you go to Home Depot and you buy a great deal of lumber and plywood and nails and all that kind of stuff, that's personal property when they sell it at Home Depot, and when you buy it and when it's in your truck on the way to a job site or to your home. And then when you put it together and assemble it in a way that's kind of difficult to take apart without being terribly destructive, then that becomes a fixture and part of the real estate. So your home, once it's fully built, is in fact real estate at that point.
And once it becomes immovable, that's part of the land.
It's the main characteristic is that personal property can be taken off of land non-destructively. You don't have to engage in any kind of major destruction or untethering of it from the property for it to become movable.
So you mentioned going to Home Depot and a transaction to get lumber, for example. That's a pretty simple transaction, right? If I go into Home Depot and I buy lumber, they're going to say, let me see your cash or your credit card, and we'll give it to you right now. Real estate, not so much. What is the process of either buying or transferring real estate?
So when you go to Home Depot, you're pretty darn sure that those items on the shelf are owned by Home Depot. And one of the major things that you have to figure out with real estate is, well, does this person own this land? And real estate transactions are also a little, I know we have a lot of contractors out there, and I have a lot of contractors that I work with and people that work for me, since I'm an investor as well, who probably spend a whole lot of money at Home Depot, especially with the price of lumber nowadays. But those transactions usually pale in comparison to the size of a transaction of a real estate transaction. So these are pretty important transactions for people, and they involve a great deal of money. Real estate has a high productive value for our society as well as the individual that's obtaining the real estate. And so you want your transaction to actually convey the property that you think is being conveyed. And so you have to be able to clear the title to the property, know that you're specifically describing it properly. And for a conveyance of real estate to be valid in our system, it has to be conveyed by a deed. And that deed has to specifically describe the parties involved, the grantor, the seller, the grantee, the buyer, and particularly the real estate in a way that is often called the legal description. Now, legally adequate descriptions can be very bare bones, cite to an address, but that's quite dangerous. It needs to be a specific legal description that uses our system, and our system in the state of Alabama is a public land survey system, which kind of creates a grid on the entire state and then tells you where within that grid that you're measuring from, usually points to start out, go up this much, go over this much, go down, and creates a, usually a rectangle, but often very wild, crazy shapes.
Right.
And engineers help us survey those and tell us exactly what the legal description should be. But those legal descriptions then have to be put inside the document, and that document then has to be signed by the grantor. The grantee, the person that's actually buying the real estate, they're important. We need to know who they are, but they don't actually sign the deed. They just are receiving the property from the grantor. The grantor is the only person that signs. The grantor or grantors, if there are multiple people who own the property, have to sign it, and then they have to do that in the presence of a notary. You can do it with witnesses, technically speaking. This is not a good idea, as we would like to have our notary, because then it's a self-proving document.
Mm-hmm. Can I ask, it's always interesting to me, the different attorneys you guys have on, kind of how they got into doing what they're doing. And this is such a unique sort of individual kind of area of the law. What was it that drew you to this specific area of the law?
Well, my grandmother's a genealogist, and I grew up in courthouses around dusty old books. And I spent a lot of time looking on those books and trying to figure out what exactly they were talking about. A lot of those books were deed books. Right. And so I've always been very interested in history, and that kind of led me to law. Mm-hmm. And I started on the path to being a real estate attorney because people were constantly asking me questions when I purchased my first home about the area that was around. So, my clients first came to me in the real estate context from the place I was in.
Right.
And real estate is a very place-specific kind of practice of law. You get to know a lot about a place. Right. You get to know a lot about the people and the history of what's going on. Mm-hmm. So.
Yeah. It sounds like was it your grandmother who was the genealogist?
Yeah, she was.
You're kind of you're studying history in a different form there.
Yeah.
All right, let's step aside. Time for our first break of the evening. Really interesting show tonight for sure. Got a lot of ground to cover. Before we head to break, just a reminder: Hollis Wright all over social media, wherever you are, they are. Just search the term Hollis Wright and you'll find them there. Really a great informational, educational resource for you. Stay tuned. We're coming right back with more of The Attorneys.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the Attorneys.
Welcome back in to the Attorneys. Appreciate you being with us tonight, talking about real estate law, and all of the intricacies of it. So with real estate being such a hot topic, if you know someone who needs to hear this show, you might want to give them a call and tell them to tune in. We're all learning something for sure. Michael?
So this is a question that I actually really want an answer to. My wife and I have argued about it. So when we bought our family home, we went to we got a real estate agent, and then there was a bank that was involved that financed, I guess you would say, and I have a mortgage on that home, and then that became my home, and then I have to pay that out over so many years, and there was a lot of paperwork, but the bank seemed to be signing a lot of that paperwork. They were mentioned in all of that paperwork. So my question is, when you finance a home and you get a mortgage, are you the legal owner of that home, even though it's not paid off, or do you become the legal owner once you pay off that mortgage?
So, in Alabama, now there are two different types of jurisdictions in the United States. There are title states and there are lien states. In some jurisdictions, a mortgage is a mere lien against the property, and they usually have a little bit more of an involved foreclosure process because of that. In Alabama, we're a title jurisdiction, so you are actually conveying part of your title. And I don't want to get into the like complex theoretical specifics of exactly how a mortgage is characterized as a conveyance, but it is a type of conveyance where you give title to the property to that bank, but it is subject to basically defeasibility from that condition of paying off the loan. So while you do own title to the property because you have your deed, you immediately turn around. Of course, this is why closings are complicated in bank transactions, because the bank's the one with the skin in the game usually. They have 80 to 97% of the purchase price, 80 to 100% of the purchase price is sometimes fronted by the bank. So it's really important to them to make sure that there's clear title. For example, the title insurance is mostly for their benefit. And so when that transaction occurs, you get title to the property immediately, but then you turn around immediately, and they want that deed to be like, imagine a stack at the courthouse of deeds that have been brought in by people. They want that deed to be right there, and they want their mortgage to be right there under it, the very next one.
First one.
And they're usually numbered that way if you look through the probate record, because they're all numbered sequentially. So you turn around and you convey an interest in that property. However, that interest in the property once you pay off the mortgage, that condition is satisfied and it reverts back to you. And they're supposed to cancel the mortgage, and most institutions nowadays do. However, there are uncanceled mortgages out there that have been paid off for years. And that's one of the title clearance issues that I typically handle. So.
Unfortunately, I think my wife won the argument.
That's probably usually the case. This is also why we have him on the show, because he went to a deep dive there. Smart dude. All right, a question we've got here. What is a quitclaim deed? What is the difference between a quitclaim deed and a warranty deed?
So the fun thing about a quitclaim deed is I can quitclaim you the Brooklyn Bridge, okay? And if you're willing to pay for my quitclaim deed to the Brooklyn Bridge, then we're done, and I don't have to worry about you coming back and saying, well, you don't own the Brooklyn Bridge, because when I convey something to you via quitclaim, it doesn't have any warranties of title. Most of the deeds out there that people obtain in investment context, always in a conforming loan, that is a bank loan that's government-backed context, those deeds are usually warranty deeds, special warranty deeds, or general warranty deeds. A quitclaim deed is completely without warranty. It doesn't say, it doesn't guarantee you that I own the property, that I have not mortgaged or liened that property. You can have many, many mortgages on the same property, first, second, third, fourth, they're all in order of priority. It doesn't say that somebody gave me the deed in the first place. All it says is, whatever it is that I own of this, I am giving it to you. And there's a good reason out there to have quitclaim deeds, because quite often we have individuals who, you know, the title's pretty murky. We don't know exactly what they have, but it looks like maybe they inherited some fraction. And, you know, you get into, let's talk about genealogy, you get into some pretty complex fractions when you start trying to figure out who owns, you know, several generations after a deed holder has passed and perhaps their descendants have passed, and trying to figure out all those people. Some pretty complicated fractions of that property are owned by tons of different people. And so those people might just go ahead and quitclaim, but they wouldn't want to give a warranty deed because they don't know exactly what it is they own, but they know they might own something. And, you know, we're all just trying to make the title insurance issuers happy so that they know that you own, you know, the vast majority of the property. Right. A clear title, all of it is what they really want.
One of the, I keep going back to the Home Depot, and I apologize, but you were talking about, you know, the lumber, that's not real property, but then when it becomes a fixture on the land and you build the home, that's part of the real estate, that is real property. I was thinking, I'm from South Alabama, rural South Alabama, and I started thinking about mobile homes and how, is that real property? Because technically you could move them off the property, but that is a home.
So mobile homes can be either, but when a mobile home is born, it's born in a factory, right? So it's built in a factory and it is personal property. When it is movable, it typically comes in on a trailer that has axles, wheels, and a tongue, and to pull the trailer with. When you take that piece of property, I should say, mobile homes being movable, they're titled in a central registry like your car is. Okay. So their default setting is to be titled as in that central registry like a vehicle or like a trailer. And so once you move it to the property, though, most people, I don't say most people, I'm not sure it's most people, but I would say a large percentage of people, when they take a trailer and they put it on a piece of land, their plan is for that to be a house, for it to stay there. You know, typically the trailer is very large, or I should say the mobile home is very large. The trailer part that's moving it along is not typically, you know, something that you want to reuse a whole lot. And the axles and everything are taken off, and the tongue's taken off, and the mobile home is there to stay. And quite often it's anchored down to the property so that it can't blow away as easily, for example, in bad weather. Right. It often has underskirting and all that kind of stuff. And so there is a process legally by which you can cancel the vehicle title, and you basically, we call it annexing to the property.
He knows too much, I think. You got a lot of info up there.
Sorry,
man.
I don't.
It is. No, it's fantastic. That's why we got you on. We just got to have you back. We're stepping aside. Our final break of the evening is coming right up. Stay tuned. More of the attorneys right after this short break.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WBTN 13.
Welcome back into The Attorneys. 5.5 minutes remaining in the show, so if you want to take advantage of the opportunity to speak with attorneys who are standing by live, about 5 minutes to do so. Michael?
So one of the things that hit me, you talked about, you could quit claim me the Brooklyn Bridge and I could buy it from you, but I guess I wouldn't own, you don't own that free and clear, right? So I wouldn't own very much of the Brooklyn Bridge. How important is it, at least for some people, I guess, to make sure that you have complete and total title, and do you deal with clients who come to you for that very reason?
So I deal with a great many clients, and like I said, you know, ranging from the largest banks all the way down to the smallest investors. Everybody wants to have clear title to their property, and so I'm sorry if I quit claim the Brooklyn Bridge to you, you're not getting clear title to that. I don't know exactly who owns it. I think it's the state of New York or, you know, the Port Authority or something like that, but they definitely have title to that property. And so you'd be a fool, honestly, to take my quit claim to the Brooklyn Bridge, especially if you pay a significant amount. Now, if you just wanted the document and give me $1, I could do that for you, but, you know, otherwise I wouldn't feel too great about it. There's a lot of people out there who, you know, wouldn't have a problem selling you property they don't own, and that's, you know, some cases that's malice, some that's they just don't know what they own. You know, we have problems of property goes through an inheritance situation, somebody passes away, then obviously if they don't have a will, then their kids get it, then their grandchildren, and it goes down many, many generations, what people call heir property. And this is one of the many title clearance situations that we often deal with. We got to round up all the folks, figure out, you know, we have to figure out who inherits under the intestacy statute, like who are the actual people who have their own little undivided fractions of the property that they all own together, because that's what happens by default if nobody had a will and they don't convey the property by an instrument, a deed. You know, we do a great deal of research to figure out who owns interest in the property. Properties are also not just trying to unravel what people own pieces of the property, but also are there encumbrances out there. So for example, if one owner who owns 1/10 of the property has a judgment lien against them, this is a problem. If the single owner property has a judgment lien against them and it's only a couple of years old, this is a problem. But if it's 25 years old, then this may not be a problem. And so we have to go through and determine what sorts of liens and encumbrances of all kinds. Mortgages are out there, second, third, fourth mortgages. Like I said, there can be many mortgages on one property. There are different types of liens. There are judgment liens. There are property tax liens. There are federal tax liens, which are kind of like judgment liens that operate against all of the person's property, and they'll get recorded in the courthouse. And if they're recorded there in the courthouse, then they're valid against that property, and it's not clear, and it can't be sold until such time as those liens either expire or they're cleared. And so we have to, track down people. Sometimes it's very difficult to figure out who the people are we need to track down. And in some circumstances, we'll have to file a particular type of lawsuit called a quiet title, where we quiet the title in rem, that is, against the actual property. Right. It's a lawsuit where we don't really know who all owns it. So we have to sue the property itself, which is kind of strange, as well as the people involved, that we can figure out who they are. And then the court appoints an attorney to sort of act as the advocate for the hypothetical people that might be out there, just in case, the judge doesn't want to trust that I could only find 2 people. Well, actually, it's really easy to find 5.
This is why you need an attorney before you dive into this. We've got just about a minute 20 left, but real quick, I want to give you an opportunity just for a final thought, real quick final thought for our viewers.
Well, a lot of people are investing right now. Real estate is really hot, and I want people to be very mindful of what they're getting into if they're purchasing a piece of property now. When you are involved in a bank transaction, you kind of got training wheels on for that transaction, because the bank is the one with the skin in the game. Right. They're the people who have the money, and so they'll make sure that the title is clear and it's conveyed to the right person and that all of the documents look good. That closing attorney is really there for the bank's benefit.
Right.
In a cash sale situation, you've got to make sure that you're getting for your $5,000 cashier's check that you buy some small lot that you plan to fix up one day. You need to make sure that you're actually getting that lot from the person who can sell it to you.
That's why we go to a guy like you. We're just about out of time. Thank you for your time, Michael.
Absolutely.
Appreciate it.
Call him.
There's no doubt about it. He knows his stuff for sure. Appreciate both of you being with us tonight. Appreciate you being with us as well. Thanks so much, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.